Okay, it's good to see all of you. Today's our second and final part in our two-part series on capital punishment. It's okay if you didn't come last week, you'll still be able to follow. But last week we kind of looked through pretty comprehensively the all the commandments in the Torah for which if a person violates them, they receive capital punishment. And then at the very end, we saw a famous Mishnah from Makot, which describes how, according to some opinions, a vicious court is one that uh, executed someone once in 7 years, according to another opinion, once in every 70 years. And then Rabbi Akiva and Rabbi Tarfon came along and said that had they been around at the time of the Sanhedrin, they would have basically no one would ever have been put to death. And then we saw a snippet of their explanation of kind of how they would do that by asking extremely precise questions of the witnesses. And then the two witnesses who come and testify that so-and-so committed a capital crime, if there's some inconsistencies within their testimonies, then the case would essentially be thrown out. So today we're going to look into a little bit more detail about that. And then we're actually going to really navigate our way to some broader questions, both about how and or why there is capital punishment and what that might mean, but also what's kind of going on when we think about Jewish law and why we're studying these texts, especially if they're not exactly relevant in a very practical sense to how we live our lives today. So I'm going to share my screen. You should have received an email from me about 45 minutes ago. You can always go to that website, and that same link will have our sources. So one moment. Okay. You should be able to see our screen now. So there are a couple of points that I really wanted to emphasize or bring some examples of. If we look at the Torah, again, we have kind of case after case that seems to say a person shall surely die for a particular violation. And if one just reads the Hebrew Bible, the books of Moses, those 5 books, one could come to the conclusion that it's very clear the Torah supports the death penalty. And yet, as we touched on already last week, the rabbis who are kind of making the canonical decisions of how the Torah itself is interpreted, some by inherited tradition, the Torah Sheba'al Peh, the oral Torah, but also ways that they themselves are innovating. They seem to kind of take things in a different direction. And I wanted to make sure that I brought some examples that I think you should have and know when you're thinking about kind of what are the various positions on the death penalty. So one which is important to know is how the rabbis did basically everything they could to make sure that no one would be put to death who was innocent. And so we read in a Mishnah in Sanhedrin the following. When the trial has ended in a guilty verdict, so someone is now being found guilty of a capital crime, and the condemned has been sentenced to be stoned, he, could be she, is taken out to be stoned. The place of stoning was outside the court and a little beyond it, as it is stated with regard to the blasphemers. That's one of the cases in the Torah where someone, there's a narrative of someone violating a capital crime. Take out him who has been cursed outside the camp, and let all that heard him lay their hands upon his head, and all the congregation, let them all stone him. One man stands at the entrance to the court with cloths in his hand, and another man sits on a horse at a distance from him, but where he can still see him. If one of the judges says, I can teach a reason to acquit him, the other, meaning the man with the cloth, waves the cloth as a signal to the man on the horse, and the horse races off after the court agents who are leading the condemned man to his execution, and he stops them, and they wait until the court determines whether or not the argument has substance. Right, so the case has already been concluded, but now one of the judges is rethinking the case, and so we have this mechanism in place where they can sort of speedily put the process of execution on pause. And even if he, the condemned man himself, says, I can teach a reason to acquit myself, he is returned to the courthouse, even 4 or 5 times, provided that there is substance to his words. So you can imagine someone's being taken off to their death. They may come up with complete nonsensical reasons of why they're innocent. So there's some limit to this, but nevertheless, on a fundamental level, the person who's been sentenced, they themselves can still come up with reasons to advocate for themselves. And if there's any legitimacy to them, they review them. If after the condemned man is returned to the courthouse, the judge finds a reason to acquit him, they acquit him and release him immediately. But if they do not find a reason to acquit him, he goes out to be stoned. And a crier goes out before him and publicly proclaims, so-and-so, son of so-and-so, is going out to be stoned because he committed such and such a transgression. And so-and-so and so-and-so are his witnesses. Anyone who knows of a reason to acquit him should come forward and teach it on his behalf. So we're talking about, right, the case is essentially over. And nevertheless, there's still a procedure in place to do everything possible to make sure that if this person is actually innocent, all evidence on their behalf will be brought to bear. All right, and even the witnesses themselves, they announce publicly who those witnesses are. So therefore, if someone has reason to believe that those witnesses might be lying, then they too can come forward and present evidence. The kind of paradigmatic case of a false witness in the ancient court system is that someone testifies. Let's say I had testified as a witness against someone else. Someone comes forward and says, there's no way that I, Donnie, could have seen or witnessed the crime because Donnie was with me in a completely different place. Therefore, they announce the witnesses here because if someone can come forward and say, I know for a fact that that person wasn't actually present at the crime scene, that can nullify those witnesses, and even worse, they'd get punished, but also throw out the court case. Now, Rambam states in kind of broad strokes, not just a technical piece, which we just saw, but Rambam Maimonides explains the kind of philosophy behind this. And he says, in the realm of the possible, some possibilities are extremely probable, some are extremely unlikely, and then there's the full broad gamut of possibilities that fall somewhere between these two extremes. If the Torah were to allow the courts to punish an individual in an instance where the probability of guilt is almost definite, then the courts would also come to punish in cases in which the guilt is less and less probable, until they would execute defendants based on flimsy estimation according to the judge's imagination. If we do not inflict punishment, even when the offense is most probable, the worst that could happen is that someone who is really guilty will be found innocent. But if punishment was implemented based on circumstantial evidence, it is possible that someday an innocent person would be executed. And it is preferable that 1,000 guilty people be set free than to execute one innocent person. So the final line there from Maimonides conveys, I think, a certain ethic of how we think of capital punishment, which is that, sure, on some theoretical plane, if we knew for certain that a person was actually guilty, then yeah, we think that they should be executed. Now, this you can disagree with, but this kind of definitely falls in line with what we see is true in the Torah, which is that capital punishment is something that seems to be sanctioned. At the same time, one of the biggest problems with capital punishment is not on the theoretical, but is on the practical. How do you ensure that you're putting to death the right person? And what Maimonides here says is that even if you put to death one innocent person, that itself is worth freeing many, many guilty people. Now, one could make an argument from a utilitarian perspective to say that's not really the case, right? Because we need to, in fact, carry out capital punishment to have a sufficient deterrent. And it's true there may be some tragedies where the system doesn't function as it's supposed to. Nevertheless, overall, for society, that's a worthwhile trade-off. But Maimonides is not saying that here at all. Here he is really lying very far on the side of we never want to execute someone improperly. And then his first paragraph is also interesting because he seems to be saying there that even in cases where we can basically be certain, once we open up the opportunity to take someone's life through capital punishment, inevitably that will lead to mistakes that will be made in other circumstances. And I think there are many ways in which our current system in the United States, we certainly see that to be the case. Again, that doesn't mean someone would say that you definitely can't have capital punishment, but it would just say that, until we see a system that can function properly, it's probably best to not have capital punishment unless we put innocent people to death. And this harks back a bit on some of the things we talked about last week, which is balancing this notion of not wanting to execute the wrong person, not wanting to carry out capital punishment more generally, but also that if we don't have that, the statement in the Mishnah that's often ignored, that that could actually lead to more violence within Israel. So again, on a utilitarian perspective, this might not be a fully cogent argument, but there may be a more kind of essential argument here that nevertheless, on the Kantian level, we never want to put an innocent person to death. So I wanted to bring those to demonstrate a little bit, both on the kind of philosophical plane for Maimonides, but also that case in the Mishnah, just how much we want to make sure we're not putting to death the wrong person, and how severe doing so would actually be. Now, there are other ways in which the rabbis in the Mishnah and the Gemara try to limit the circumstances under which someone could be executed. But there's also, I think, a kind of theological point which is made in the Mishnah in Sanhedrin, which also conveys a sense of how the rabbis thought God thinks about criminals. And you read there a very powerful statement from Rabbi Meir, who says, the phrase for he that is hung is a curse of God. This is a statement in Deuteronomy, in Devarim, ki kilat Elohim talui, that after you put someone to death, and then you hang them. Actually, hanging is not one of the form. You're not hanging someone as a way of killing them, but after you killed them, you would then hang them. But you wouldn't be allowed to leave that person hanging overnight. You have to take them down. And the phrase that's used there is this ki kilat Elohim talui, that is hung. The person who's hung is a curse, or the act of hanging them is a curse of God, and should be understood as follows, says Rabbi Meir. When a man suffers in the wake of his sin, what expression does the divine presence use? Meaning, what does God say? God says, I am distressed. And it's a similar word to kilat, kalani. I am distressed about my head. I am distressed about my arm. Meaning, I too, meaning God, suffer when the wicked are punished. And the statement actually, just, when we're looking at a translation from the Talmud, I'm using what you can find on Sefaria, which is the literal translation is in bold, and the non-bolded is the additional words from the Koran translation to just help make it a little more understandable. So actually here it doesn't say in the wake of his sin. So the actual statement is when a man suffers, what expression does the divine presence use? I am distressed about my head. I am distressed about my arm. And this relates a bit to a class I taught earlier this semester on suffering, and this notion that God suffers along with us. But in this context, it's very clear this is referring to someone who is a criminal. And so that's very powerful. And the Gemara then continues. From here it is derived, if God suffers such distress over the blood of the wicked that is spilled, even though they justly deserve their punishment, it can be inferred, A, for fortiori, meaning all the more so, that God suffers distress over the blood of the righteous. But the main point here is just how powerful this notion is on a theological level, that even if execution has to be carried out, it doesn't mean that there's kind of joy happening, that God suffers alongside this person's suffering. And so I think just on a kind of a broad level for us to recognize that even if there were to be capital punishment, and true also of less severe forms of punishment, it doesn't mean that we don't care for the criminal. One other point here, it's only tangentially related, but I thought it was important to include. And the sages said not only this, that an executed transgressor must be buried on the same day that he is killed, but they said that anyone who leaves his deceased relative overnight without burying him transgresses a prohibition. But if he left the deceased overnight for the sake of the deceased's honor, meaning to bring a coffin or shrouds for burial, he does not transgress the prohibition against leaving him unburied overnight. And I want to bring that because you may be familiar with this general notion that we try and bury a body quickly, in Jewish tradition. In Israel, that often happens the day of. In the United States, often people try and bury the body by the next day. And there is this notion that we want to bury the body as quickly as possible, and it comes from this case of the transgressor who, when they're being hanged, their body just hanging there is seen as a curse to God. In some ways, because the human being is made in the image of God, and that may even be understood physically, which is a topic in and of itself. And so if you're kind of hanging a body there, it's as if you're hanging God there. But that's why we bury a body as quickly as possible. Nevertheless, as you already see here, in the event that waiting will be for the honor of the deceased, then we can do so. Here, they're very specific things that are mentioned, but this can also be true, right? If the family can't get to the funeral in time, then maybe you want to wait so they can be present and there can be greater honor. And certainly sometimes when there's a case of a dignitary who's been killed, let's say like in the assassination of Yitzhak Rabin or when Shimon Peres died, may delay the funeral even longer so that other important people can come and bring honor to the deceased. Again, it's a tangent, but I just wanted to share that with you. Now we see that really generally speaking, it's very, very difficult to carry out an execution given all of the procedures that are involved. And a couple of the specific things that are mentioned are cited in Sanhedrin, where we read the following, Daf Chet Amud Bet 8b, and the matter is in accordance with this Tana. A Tana was a teacher from the time of the Mishnah, an ancient rabbi, whose statements as follows. As it is taught in a Braita, with regard to all the others, those who are liable for the various death penalties stated in the Torah, other than the inciter to idol worship, we saw that last week, the court executes them only when the following elements are present. The congregation represented by the court and witnesses and forewarning just before the defendant commits the transgression. I mean, you need to have a court, you need to have witnesses, and you need to, most importantly, have this warning, which is issued by the witnesses. And the court does not execute him unless the witnesses had informed the defendant that he is liable to receive the death penalty from the court. So think about what that means, right? Before someone's carrying out this crime, not only do they have to have witnesses who see them, which would assert that there's evidence that the person actually committed the crime, but the witnesses have to warn the person right before they commit the crime that if they commit this crime, they're liable for the death penalty. Rabbi Yehuda says the defendant is not executed unless the witnesses had informed the defendant by which form of death penalty he is to be killed. So we see already here the extreme level that the Mishnah and the Gemara goes to have procedures that would make it nearly impossible for someone to be found guilty. And, right, even let's say someone really wanted to carry out this crime, if two witnesses are there and the witnesses warn him, you would imagine that's a pretty strong disincentive for them to carry out the crime in that moment, and they might wait for another opportunity. Now, we are going to return to this notion of why this warning is so important. But for the meantime, I think I just want to emphasize that sort of the level of detail that needs to be in place for the court case to allow for capital punishment. And the Talmud in Sanhedrin 40b goes even further. And there we read, the sages taught in a Braita, in a trial for murder, the court asked the witness, do you recognize the accused? Did he kill a Gentile? Did he kill a Jew? Did you forewarn him? And then this last piece, did he accept the forewarning on himself? Meaning, did he acknowledge the warning? Did he release himself to death? Meaning, did he acknowledge that he is aware that the court imposes capital punishment for murder? Did he kill within the time required for speaking a short phrase? And if not, he could claim he forgot the warning. So there needs to be a warning. The murderer needs to accept the warning upon himself, and it has to happen in such a short period of time. This notion of betoch de dibor, speaking a short phrase, is typically understood the amount of time it takes to say Shalom Aleichem Rebbe, to say to your rabbi, basically hello, just a couple of seconds. So we're saying that there has to be this very clear evidence that the person knew what they were doing, knew the punishment they were going to receive, acknowledged that, did it anyway, and did it so quickly that there's no doubt that they were fully aware not only of the act that they were doing, but that it was wrong and that they would be punished for it. Again, we're going to come back to this in a bit through a Talmudist named Devorah Steinmetz and how she understands the significance of this text, but that's for more towards the end of our class. Now, all of this being said, we read in Sanhedrin 41 that basically the courts did not carry out these cases. This is now a historical statement, not just the statement we saw before from Rabbi Akiva and Rabbi Tarfon, that had they been around, they would have made sure that courts didn't carry out execution. But pretty early on, these cases were stopped. And we read is taught in a Braita. A Braita is a compilation of Tannaitic texts. 40 years before the destruction of the Second Temple, the Sanhedrin was exiled from the chamber of hewn stone, meaning the high court was moved from its place just opposite the temple, and sat in the store near the Temple Mount. Rabbi Yitzchak bar Abodimi said, the intent of the statement concerning the relocation of the Sanhedrin is to say that the Sanhedrin no longer judged cases of capital punishment. Once they left the chamber of hewn stone, the court's power to judge capital cases was nullified. So the main Sanhedrin had to be in its official place, and once it wasn't, they essentially stopped carrying out capital punishment. So one thing that we may want to ask is, if historically, basically capital punishment stopped at a very early stage, and certainly it hasn't been carried out since the exile, Jews just haven't even had that autonomy, and we're not supposed to carry these things out if all the right ingredients are in place, with the Sanhedrin, the high court, sitting where it's supposed to in Jerusalem. So if that's the case, what are we doing kind of studying all these texts? And this leads to a much broader question about the purpose of the study, especially of Talmud, but of Jewish law more broadly. Because on the one hand, we may think we're studying these laws because they may be practical. And for some of us, depending on our observance level or how strictly we want to adhere to these laws, there may be elements of them that really are more or less practical. Nevertheless, certainly the laws surrounding capital punishment are not practical, and therefore, why might we study them? And to address this question, I want to turn to a professor of law at Villanova, but also very learned in Jewish texts, named Chaim Saiman. And he wrote a book maybe close to 10 years ago at this point called Halacha, meaning Jewish law, the rabbinic idea of law. And I want to quote extensively from him because I think he makes a very powerful point and might help us understand what exactly Jewish law really is, why in traditional settings in the yeshiva or seminary, people spend so much time studying the Talmud, when it seems as if a lot of these laws are not actually practical. And he explains the following. He says, while galut, exile, rendered Judaism's central institutions inoperable, one of halacha's, again Jewish law, one of halacha's most astonishing features is that, at least some of the time, it is spoken as if it governs a broad array of public institutions. Perhaps the most famous example is the Talmudic discussion regarding the law of capital punishment. On the surface, little in the Mishnah's treatment of capital punishment reveals that by the time these texts were disseminated, these laws were no longer operative. Right? All the time the rabbis are writing the Mishnah, there's already no Sanhedrin anymore. There's no capital punishment. 5 of Tractate Sanhedrin's 11 chapters are devoted to these laws. 3 to the underlying offenses, and 2 to the penal procedures involved, penal procedures themselves. And yet, in the rabbi's own recounting, the Sanhedrin, the high court that sat in Jerusalem, ceded its capital jurisdiction 40 years prior to the temple's destruction in 70 CE, well before the Mishnah's publication. Further, by all accounts, no such institution functioned after the fall of Jerusalem and the full assumption of Roman rule. And the Mishnah itself describes considerable hesitancy over administering capital punishment. Despite the practical irrelevance of capital punishment, however, the Mishnah, and later the Talmud, developed an elaborate procedure detailing how it would be or should be administered. Further, when discussing the topic, the Mishnah does not speak of an idealized past, but rather in a declarative tones of the governing present. But if we assume that the Mishnah speaks of an era when the Sanhedrin enjoyed the full panoply of its powers, executing a criminal under Talmudic law would still be all but impossible. Though many specific elements contribute to the legal nullification of Talmudic capital punishment, none is more striking than the process by which the criminal had to consent verbally to his judicial execution, known as hatra'ah, literal warning. So basically, what Chaim Saiman is saying is that by the time the Mishnah even comes along, all these texts that we saw last week and this week, right? Already by that point, there is no capital punishment taking place because the courts don't have their jurisdiction anymore. And yet, the Mishnah is speaking in sort of the present. These are the things that should be done, even though they're already practically irrelevant. And as he says, basically, because of all the procedural details, it would be nearly impossible to carry out execution. It seems strange that the rabbis are spending so much time talking about how executions would take place. And that's where Chaim Saiman gets to, well, I'm actually going back to his intro, but where he explains what exactly we are doing when we're studying halacha, not just in this particular case, but more generally. And he says the following. He says, this book will argue that halacha is not only a body of regulations, but a way, a path of thinking, being, and knowing. Over the course of several chapters, we will see how the rabbis use concepts forged in the regulatory framework to do the work other societies assign to philosophy, political theory, theology, and ethics, even to art, drama, and literature. Right? So what he's saying is, if you were to, say, go into a yeshiva and look at how people are spending hours studying law that seems like it's not practical and kind of irrelevant, and ask, what are these people doing? The real answer is they're doing the same thing someone's doing in a university. And it's not structured exactly the same way or divided up into subjects in the same way. But basically, when someone is studying Jewish law, they're studying ideas of all different types. As he says here, philosophy, political theory, theology, ethics, art, drama, etc. And he gives a bit of an example later on in the book. He says, what is beauty? What is truth? What is the best political ordering? The Talmud anchors such macro questions in the context of a specific mitzvah and its obligations. Thus, the issue of how many judges should sit on a panel is approached by considering whether the role of a court is to secure social peace or to determine legal truth, right? That's a question that you can imagine someone would be discussing in a Harvard Law School class. Which books are deemed part of the Bible is assessed through a discussion of which books are rescued from a building burning on Shabbat, or which scrolls transmit ritual impurity. What we now call the life-work balance is negotiated in the Talmud by weighing a worker's contractual obligations towards his employer versus his religious obligations of daily prayer. In brief, what the Greeks pursued through reflective and speculative philosophy, the rabbis read into, out of, and through halacha. And what I love so much about this text and Chaim Saiman's book in general, by the way, he was a visiting professor at Harvard Law School a few years ago and just absolutely phenomenal. He's doing comparative Jewish and American business law. But I think so much of what maybe always percolated for me subconsciously, but I never knew how to articulate, but he does articulate it, is that Jewish law can actually be an incredibly enriching way of discussing all kinds of ideas. And sometimes in some of the classes that we've had together, we're looking at things that are directly related to law, sometimes other ways of approaching things like through Midrash. But when we are looking at law, my hope is that people, you all, don't think, how exactly is this particular esoteric law or something that I may not actually feel bound by? How exactly is that relevant? Well, the real answer is because everyone who is studying Jewish law is really engaged in a broader discourse of these questions that extend to all different fields, questions of virtue and value and many other things. And that's kind of what we're trying to do more generally. And I want to bring this text to kind of for us to move a bit out of the particular case that we're talking about, capital punishment, and think more broadly. And as we see here, capital punishment really is significant in Chaim Saiman's argument. So given that this is the case, right, that these laws are irrelevant in a practical sense, even by the time they're being written in the Mishnah. So what are kind of the major ideas and values that are being discussed? So we've already seen some that relate directly to capital punishment, right? That there seems to be a hesitance on the part of the rabbis to want to carry out capital punishment. But there are some other details in the laws that discuss and describe capital punishment that actually, I think, address some broader questions that aren't just relevant to capital punishment itself. In the Mishnah in Sanhedrin 7:2, we're not going to read it inside. It's rather gory, so if you want to read it, you're welcome to, but please be forewarned. But there, we see that one of the forms of the 4 forms of capital punishment is sreifa, literally burning. And I think when you think of someone who is being burned as a type of death penalty, you kind of imagine witches being burned. But actually, the procedure is very different and is a kind of internal bleeding that takes place inside the intestines. And again, I don't want to go into the detail. You can look at that if you want. But the main point is that we're not burning someone on the outside. We actually end up burning them on the inside. And the final statement of this Mishnah says that an incident occurred. This is right here, about 5 lines from the bottom. An incident occurred with regard to a certain priest's daughter who committed adultery, and therefore her punishment was to be burned. And they wrapped her in bundles of branches and burned her, which is, I think, how many of us would think execution through burning would take place. But that's not how the Mishnah is just described in the gory detail. I'm not going to say out loud. But then the conclusion here is the sages said to him, that court did not act properly. They did so because the court at the time was not proficient in halakha, in Jewish law. The main point here being that capital punishment of burning carried out by the standard way, I think we would all assume burning is meant to convey, is actually not what the Torah means, or the rabbis understood the Torah to mean by burning. So why is this important? Because well beyond questions of capital punishment, we see here that the reason, what happens when you kind of carry out the execution of burning through an internal burning, it means that the outside of the body actually remains much more intact and uncharred and unmarked. And so we can see already, thinking of a general sense of value, that the outside of a human body, how a person appears, a certain kind of dignity that comes along with that, may have some significant value, such that even when we're killing someone through an execution, we want to preserve the outside of their body. And this could relate more to what we saw before of the notion that you want to take down the body that's hanging because we're seen to almost be physically the image of God. And a similar point is discussed in the Talmud in Sanhedrin over a question of kind of the dignity of a person and potentially their appearance versus their pain and suffering. Rabbi Nachman says that Rabba Bar Avu says, the verse states, you shall love your neighbor as yourself. I hope we're all familiar with that. Teaching that even with regard to a condemned prisoner, you should select a good, meaning a compassionate death for him. And that notion we've already seen, this sense that God suffers when even a criminal is suffering, and that in and of itself is already an important value being conveyed in this text. But it goes further. One sage, meaning the rabbis, said the following: minimizing one's degradation is better for a person than seeing to their physical comfort. I.e., minimizing his pain, his physical pain, right, is better for a person. It's a person is willing to give up on their physical pain and suffering for the sake of their own dignity and lack of preventing degradation. Therefore, the rabbis view the more compassionate death as one without degradation, even if wearing clothes will increase the pain of the one being executed, as the clothes will absorb the blow and prolong the death. The question here is whether or not when you're stoning someone, you should do so and they should be naked, stripped of their clothing, or they should be clothed. Somehow the understanding here, the clothing could somehow blunt the force of their death. And one sage, meaning Rabbi Yehuda, holds that one's physical comfort is better for him than minimizing his degradation by being naked, and therefore the one being executed prefers to be stoned unclothed without any chance of the clothing prolonging the death, even though this increases degradation. And this question is one that would extend beyond the question of capital punishment, a question of how do we balance a person's sense of dignity versus a person's sense of physical pain. This comes up, very often, I think, with people who are aging sometimes, that they might be prepared to kind of struggle to do something independently to preserve their own sense of self and dignity. Not that it's undignified to accept help from someone else, but sometimes many of us feel like my dignity, I want to have my independence. And even if that actually is the less comfortable way of doing something, it could be easier for someone else to help a person. But that in terms of how comfortable it is or pain and suffering, but that can be an infringement upon their dignity. I have a distinct memory once of when I was in rabbinical school living in New York and walking with a friend, and there was some senior citizen, a woman who was kind of struggling to carry her packages upstairs into her apartment. And my friend, who really just wanted to help, ran over and said, let me help you, let me help you. And she pushed him away sort of 2 or 3 times. And he sort of felt that she was being polite, but I think probably what was happening there was, she was struggling to schlep those packages, and he, being kind of a strapping 25-year-old, would have been much easier. Nevertheless, this sense of her dignity in her independence was worth her own physical discomfort. And so, following Chaim Saimon's understanding of what we're doing when we're studying Jewish law, on first glance, at first appearances, this seems to be a text which is talking about legal questions of how we're going to kill somebody who is liable for execution. But actually, it raises a much broader question of this notion of comfort versus dignity. And so that helps us, I think, to understand that these laws, which, again, weren't even being applied at the time that the rabbis were writing the Mishnah, and certainly not by the time of the Gemara, nevertheless, there's still a worthwhile conversation to have, because the conversation is not really a legal question. It's a much greater question of really, of, in this case, a certain kind of philosophical or psychological question. And so we see that for us too, where these texts might not be practically relevant, there are still broader ideas that are able to be discussed and conveyed in them. So that's one notion. And there's another idea that comes out in this woman that I mentioned before, Devorah Steinmetz, of how she understands these texts, and kind of a really important notion, or implication that they have, or I guess reflection. These texts of capital punishment are a reflection of an underlying understanding of what Jewish law is all about. Devorah Steinmetz is a Talmudist. She's one of the founders, along with her husband, of an institution called Drisha, initially founded as a center for Jewish women's learning, one of the earliest places where women could study Talmud. She herself is brilliant, pioneer in founding this institution, and somehow managed to raise, I think, 9 children as she did all of that. And she writes the following, going back to the notion that we saw before of the significance of hatra'ah, that the Jewish violator of a capital crime needed to be warned just before they committed the crime in order for the capital punishment to be carried out. And she says the following. She says, the would-be violator of the Torah's command must both accept upon himself or herself the hatra'ah, the warning, and give himself over to death. The Gemara asks what the source is of this second requirement. The source that is offered is the phrase yumat hamet. Translated literally, this means the dead shall be caused to die. It is not then that the court imposes death on the criminal. The criminal comes to court already dead in a certain sense, because by knowingly and willfully violating God's command, he has relinquished his right to life. The hatra'ah, the warning, and the acceptance of hatra'ah elevate the crime to nothing less than a violation of God's command and a handing oneself over to death. And she continues, the rabbis see Sinaitic law, as they understand it, as a system of law that is grounded wholly in divine command, as a key marker of Jewish distinctiveness. So in a moment, we're going to follow her line of thinking to see how this contrasts with other ways of understanding law. But what she fundamentally is arguing here is that Jewish law, or certain elements of Jewish law, should not be understood as a kind of regular law just happening to be applied to Jews. But Jewish law has to do with the relationship that we have with God, goes back to the covenant at Sinai, and therefore the violation of a law needs to have this warning, because the act of violation needs to be done as an intentional breach of that covenant. So let's see exactly what Devorah Steinmetz means by this. Well, first she explains, and I'm not going to go into the detail. You can take a look at these two texts here in Sanhedrin 56a and 56b. But basically, you may be familiar, we touched on this last week, the notion of the Noahide laws, the 7 commandments that all people are meant to have to keep according to the Torah. So they apply to all the descendants of Noah. And there are 2 different places. There's a disagreement about where these laws are derived from. The first opinion, which is understood to be the sages, a certain collective group of rabbis, understands these homiletically to derive from the verse in which God commands Adam not to eat from the tree. I'm not going to go into all the details here. You can take a look if you want. But fundamentally, Devorah Steinmetz understands this to be the source for all of these laws is in a kind of command that she understands as command qua command, which is for the functioning of society. The second set of areas in which these are derived comes from Tana Devei Menashe, and there they interpret a set of verses from the story of Noah and the whole natural order of the world becoming corrupt. Those are the sources for the Noahide laws. And basically what Steinmetz understands is that in general, in kind of theory of law, there are really 2 different understandings of why we have law altogether. From one perspective, law is meant to create a functioning society. And she reads this back into the derivation of the laws for the Noahide laws coming from the commands given to Adam. And the second kind of way of understanding philosophically what we're trying to do with law is that we determine law through how the natural world functions. This notion of natural law, that we can look at how the world operates, and from that we can distill or learn broad lessons of the structure of the world, and we want to try and mimic those in our own lives. These are not her ideas. These are 2 different notions of how law was meant to be understood. And so she writes the following. She says, while the sages' list of Noahide laws, the ones that come from Adam, then is grounded in legislation and linked to the establishment of a judicial system, Tana Devei Menashe's list that come from all the corruption that was taking place in the natural order at the time of Noah does not include the obligation to set up a judicial system. That's actually one of the requirements according to the sages list. And the laws on this list do not have their source in commands. The source of the prohibitions added by Tana Devei Menashe are in verses that stress the good of procreation and of sustaining the kinds of creatures that God created. For Tana Devei Menashe, prohibited acts are those that run counter to the way the world was created. So for Steinmetz, the Noahide laws, which are not specifically Jewish, these are the laws that are applied to everyone, there's a debate as to what their source is. One of them she understands to be coming from being grounded in legislation, that there needs to be command, there needs to be order in society, founded in legislation. The opposing view says that these laws actually derive from the time of Noah and the corruption that's taking place in the natural order at that time. And this parallels another understanding in general legal theory of what laws are meant to do or how we determine what is true, or what is true on a legal level, is that we want to learn our laws from the natural world. And therefore, that set of laws, they actually debate which, what the 7 laws are. That set of laws does not include having a judicial system as part of it, because it's not about fundamentally a judicial system. It's about looking into the world, seeing how it operates, and applying those to human society. And she explains this in more detail. She says, Tana Devei Menashe is similar to natural law in its classical form. According to the classical view of natural law, the world is created and operates according to certain principles. And the content of law is derivable from observation of the world as it is. Castration is unlawful because it violates the principles of reproduction inherent in the world as it was created and as it must operate. These acts are unlawful, not because they are prohibited by a command, but because they violate the world order. In the sage's view, the content of law consists of basic prohibitions that are designed to ensure the functioning of human society. But these are not laws in the sense of normative principles within natural order. They are commands within human society. The content of the laws is limited to that which is seen as necessary for social life to function. Thus, the very first natural law, according to this conception, is the commandment of dinim, of setting up a judicial system, of having other laws. So again, the two different ways that we understand law more generally for the world, for all of humanity, is either as trying to be a reflection of the natural world, or to be something entirely distinct from the natural world, about human society. And that is fundamentally grounded in a court system. But by contrast, what is Jewish law? She explains the lack of hatra'ah, which again means warning, as a component of Noahide criminal procedures, demonstrates the criminality of behavior for a Noahide has nothing to do with intent to violate a command. Right? You're not being warned. So we're not concerned with determining whether or not you intended to violate a command. It has to do only with the nature of the act that the person has done. For a Noahide, the act is criminal in itself. While for those commanded at Sinai, the act is only criminal to the extent that the person knowingly and willingly violates the command. And so the idea here is, why does a Jew need to be warned about violating one of these crimes and they have to accept the warning in order for them to be liable for this capital punishment? And the answer is because it's not just about that there happened to be violating a particular law. It's that the act of violating this law needs to be a whole rejection of the Sinai covenant. And that's only going to be true if they've been directly warned immediately prior and they accept that warning upon themselves. Because in that case, it's not just that we're trying to figure out, did this person actually happen to violate this law? And are they guilty of violating that law? We're trying to find out is, did this person intend to essentially scorn the entire system through their act of violation? And that is only going to be true if they basically say, you know what, I hear your warning to me. You're reminding me that there is this system here. I don't care. I'm going to go ahead and carry out this crime regardless. And if that's not in place, it's true they violate a particular law, and that might be a problem in and of itself, but they haven't done so with the intent of kind of destroying the whole system. Whereas for a non-Jew, according to the 7 laws that we understand they're liable for, we care about them upholding those laws the way that we in a general American society care about people upholding laws, because they need to follow basic laws that allow human society to function, whether those laws are derived from the natural order, through the sense of legislation. That's really what matters. The notion of violating a covenant doesn't apply to people who aren't bound by that covenant, and also doesn't apply to let's say American society, where we don't conceive of our law in that same way either. I'm going to stop sharing my screen, and just kind of to conclude what we've done here. When we started last week, we looked at all of these Jewish, these laws in the Torah that are subject to capital punishment, and they seem to be rather harsh. And you would say that it seems like the Torah does, in fact, acknowledge and maybe supports capital punishment. But we saw already pretty early on that the rabbis themselves, ancient rabbis, very much blunt the force of those capital crimes and the ability to carry them out. And we see then, I think, in some ways, an ethic which is we're very concerned with punishing the wrong person, but also a general sense, I think, that we really just do want to limit how often these cases happen. Again, maybe a practical matter, but maybe even more philosophically, this notion that God cries or suffers when even a criminal suffers. The notion that even if you are going to carry out a punishment, we want to still have concern for the person who is being punished. And then we move to this broader question of, if these things never really happened, what are we doing in having a whole conversation about these details of capital punishment? And we saw that they could actually be kind of the platform for a much richer, deeper conversation that extends well beyond a particular practical legal question to a broader question of, in the particular example we looked at, the question of human dignity versus human pain, the sense that even the human body should be kept pristine, even in the act of a criminal punishment. And then we finally went on to this very specific notion through Devorah Steinmetz, that there's a fundamental distinction between how Judaism might view laws as they apply to your average person versus how we view laws as they apply to Jews. And the sense that there is law for its practical functioning, which is required, and that might be how we think about the American legal system. And then there's a sense of Jewish law, which is about a relationship with God and a covenant. And in that case, it may also be meant to serve certain ends that are standard ends of law more generally, but is also in some ways entirely distinct. And it reminds me a bit of what we saw last week from Rabbi Moshe Meiselman, a Harvard alum, where he basically said, you can't actually learn anything from the Torah's understanding of capital punishment and apply it to secular law because the two things are entirely different. I don't think he's entirely right about that. I think there are certain values that are discussed in all the conversations about Jewish law that we may want to apply more broadly. It's a question of human dignity, let's say, or suffering. But to say that at the end of the day, there may be a way in which it's important to still acknowledge that the notion of a covenant, which sort of rests at the foundation of Jewish law, is something that does make it, at least in some ways, distinct and unique from law more generally. So I'm going to pause here. I'll also stop our recording.